Supplementary list, item number 1.
Visual the order of this Honorable Court, that 13524, is sought to be reviewed for the reason that at the time of before the disposal of the petition, this petitioner has filed one reply to the affidavit of Tahsildar Hatadihi on 23/8/23, and the read application was disposed of mainly relying upon the affidavit of Tahsildar Hatadihi dated 4/5/23, and basing on that affidavit, a view was taken by the Honorable Court that the report which has been submitted before this Honorable Court by Tahsildar, that reveals there is no encroachment of land of a petitioner. There was a government land over which the road has been constructed. Therefore, on the basis of report, the case has been dismissed.
No, you come to the operative part of the order, paragraph number
Yes,
6.
yes, yes.
Please place it.
The operative part of the order is at paragraph 6.
Please place it.
Having heard the Lorry Counsel for the package, and after going through the records, this court finds that, pursuant to the order passed by this court, a joint inquiry was conducted by the Revenue Inspector Sodha and Assistant Executive Engineer RW Subdivision Hatadihi, during the course of which the land of the petitioner and land over which the existing road was constructed were demarcated, and it is found that the lands are existing as per the map published during 2017 and 18, and as such, there has been no construction over the land of petitioner, as would be evident from the report dated 24/3/23, along with the sketch map showing the exact location of the road and the land of petitioner. As such, the road stretches over plot number 3711, Khata number 1197, Sarvasar Kisam, of which Rasta does not affect the land of petitioner in any manner whatsoever. In the above view of the matter, the allegation made by the petitioner is not correct. As such, it is sought for, and the petition cannot be granted.
So what is the perversity in this order, so that we...
My respectful submission before Lordship is that the report, the affidavit,
If you come to the paragraph number 3 of that very order,
Yes,
your prayer has been mentioned there. So you are seeking for a direction to the OP1 and OP25 not to make any construction of the road question over your land.
yes,
Now the report has come that on your land there is no construction of the road, rather the road goes on some other. That is the report has come from the joint inquiry. It was conducted by the revenue inspector and the assistant executive engineer.
that report,
in view of the limited scope of the jurisdiction, the division bench relied upon that and passed the order. So what is the question?
my submission, my submission of Lordship is that report is erroneous. That does not reflect the correct position.
That cannot be tested in the read jurisdiction. If the report is wrong,
But
the government officials has submitted a report, and obviously this order must have been passed in open court.
my reply to the affidavit, which was very much on record, wherein I have clearly stated that the facts placed by the opposite party number.
So it becomes the disputed question of fact. Why it will be entertained in a writ petition? How it will be considered? If you are disputing and you are telling something else, then it becomes the disputed. How a writ jurisdiction will, in a writ court, it will be decided.
These are
It is not a civil suit. It's not a civil suit. They are
right.
Right.
On that ground, the case has not been dismissed. The case has been disposed of.
You are now, on the other hand, whatever you are submitting that the report which has been furnished by the revenue inspector and the assistant executive engineer, that is not correct.
Yes.
Right. So now correct means if suppose you would have brought some other fact. So it becomes that they are telling that there is no construction of any road over your plot. Now you will file another set of evidence, maybe documentary, whatever it may be. So it becomes the disputed question of fact. How it could have been exercised.
I agree with Lordship's view. But my respect to submission that when certain matters are placed before this honorable court, copy whereof is served on the government side, government has not rebutted these facts. Those are very material facts ought to have been taken into consideration by the honorable court.
Do you mean to say that all the documents which are filed is to be considered and the reply is to be given in the judgment?
No.
So whatever because this is the basis. You are in a writ court, you are challenging that some road has been taken on my land. So that is how perhaps the court has passed an order for joint inquiry. Joint inquiry report came that there is no construction. So matter ends there. Further, it cannot be. There is no scope of any oral evidence or.
Your Lordship is right to say, but it is a case wherein some facts have not been open number 1 to 4.
No,
they have not.
And you are now review jurisdiction means unless there is patent illegality, we cannot on the face of the order. What is the illegality? You cannot say that some other thing were not taken into and that thing becomes the disputed question of fact. We cannot take it.
Your Lordship is right. In my reply, I have tried to place with your Lordship that the road which is being indicated that this is the road existing. There is no road at all. And they are referring.
You are again asking us to, as if we will visit that, we'll send some advocates commissioner or something like that. The report has come. Listen, see that.
These aspects are not been.
Review jurisdiction, the scope is very, very limited. And
my submission before the that since that aspect has not been taken into consideration and the impugned order, this order has been passed, and if this order is allowed to stand, it is resulting in miscarriage of justice because.
Heard the Land Council for the petitioner, Land Council for the state. The review petition has been filed challenging for a review of the order dated 13/5/2024 passed by this court in WPC number 4077 of 2018. It appears that the petitioner filed the writ petition seeking for a direction to the opposite parties number 1 to 5 not to make any construction of the road in question over the land of the petitioner connecting Nittigadia Chowk to Halagadia under Mauja Gram Panchayat Sada in the Hatha Dihi block in the district of Keonjhar, which according to the petitioner was in gross violation of the agreement dated 22/12/2016. Further, prayer was made for a direction to the opposite party number 1 to 4 to pay compensation to the petitioner to the tune of rupees 3 lakh for causing loss and damage to his land and causing harassment to him. After issuance of notice, the land and additional government advocate contended that an affidavit and submitted an affidavit filed by the Tahsildar Atadihi refuting the construction of the road over the land of the petitioner. And as such, it does not affect the land of the petitioner so as to get any compensation. The court passed an order for a joint inquiry to be conducted by the Revenue Inspector Sada as well as the Assistant Executive Engineer RW Subdivision Hatha. In portions of such order, a joint inquiry was conducted and the report has been furnished to this court, and it was found in the report that the land of the petitioner and the land over which the existing road was constructed, those were demarcated, and it was found that the lands are existing as per the map published during 2017-18, and there has been no construction over the land of the petitioner. अच्छा report कर देवे joint inquiry report which is dated 24/3/2023. Along with the report was filed along with this case map showing the exact location of the road and the land of the petitioner. And it was further mentioned in the report that the road stretches over plot number 3711, khata number 1197, Sarva Sadharan Kisam, which is Rasta, and it does not affect the land of the petitioner. Considering such a joint inquiry report filed this court has been pleased to hold that the allegations of the petitioner that there has been construction of road over his land is not acceptable, and accordingly no relief can be granted, and accordingly the writ petition was dismissed. The Land and Counsel for the petitioner submits that this court has failed to consider the reply dated 25/6/2023, 25/6/2023, which was filed by the petitioner, and there are materials to show that the road was taken over the land of the petitioner, for which the petitioner is entitled to get the compensation. Stop. If the submission of the Land and Counsel for the petitioner is taken into account, then it would have been the disputed question of fact, and which is not permissible to be adjudicated in a writ petition. In view of the limited scope of the judicial review, as per the decision, we find that the petitioner has failed to make out any case for review of the impugned order dated 13/5/2024. Accordingly, the review petition stands dismissed. Yes, next.
Item 2.
Complaints of order dated 24/4/2024 in WPC number 9585/2024.
Where is that order? Let us see.
Order, your lordship may kindly see page number 10 of the content petition.
Come to the operative part, paragraph number 4.
Yes, ma'am. Considering limited nature of demands made by the petitioner and as agreed by land counsel for the parties, this court, without expressing any opinion on the merit of the case, dispose of the writ petition, directing the opposite party to consider the petition filed by the petitioner under section 28A of Land Acquisition Act by the Nature 1, and pass appropriate order in accordance with law within a period of 3 months from the date of production of certified copy of this order.
When you produce the certified copy of the order?
My lord, I produce the certified copy, my lord. Your lordship may kindly see page.
Which paragraph? No, you tell us the paragraph the government's taken in the content petition.
No.
Paragraph 5 or what?
Paragraph 5, ma'am.
Hmm.
Restive post dated 11/5/2024 to the opposite party number 3.
You have given the postal receipt.
My lord, page number 12.
So previously what orders have been passed in this case? Yes, we asked you to obtain the status of the representation which was submitted, and whether there has been compliance of the order of this court. What is your instruction?
Come additional secretary, letter to the accountant general. one week time to file the affidavit.
No. It was just he has filed an application. That petition was filed under section 28A. That is to be disposed of within a time limit. Because that was not disposed of, he had approached this court, and the order has already been passed. And in compliance of that order, he has also produced the certified copy of the order. So, what steps you have taken?
21st for 25, the Director R from Additional Secretary takes the sanction of the decretal dues under section 28A of the earlier Act.
Pass on that instruction which you have received. If it has already been done, then you should produce it. Sanction it's already there. So, what is the question of contempt now? It has already been done. The Learning Council for the state has produced the written instruction receipt from Director R from Additional Secretary to Government dated 21/4/20, wherein it is mentioned that the sanction for payment of rupees 25 lakhs 10,972 only has been made towards the decretal dues under section 28A of the LA Act in favor of the petitioner. As per the judgment dated so and so. The copy the copy of the letter is taken on record. Copy the client. In view of this is disposed of. Yes.
28 Act say in view of that judgment matter enhanced pending.
Copy दियंतु से जेतिकी लिमिटेड थिला आपण ये ऑलरेडी पाई सारलेनी आपण पक्ष आपण को इंस्ट्रक्शन देई नांदी बोले. Yes, next.
Item 3. Trip order dated 18/4/2024 passed by the Honorable Court in WPC number 5364/2024 has not been complied with, Your Lordship. It was communicated both by the petitioner as well as by the Superintendent of the High Court of Orissa, which is at Annexure 2, Your Lordship.
कौन असला instruction में? But this is later dated, this order is dated, letter is dated 13/2/2024. The order of this court is dated 18/4/2024, and the order operative part says, come to paragraph number 7. Please read it out.
Yes, Your Lord. In view of such position, this court disposes of this writ petition directing the opposite party authorities to make direct purchase of land in question in conformity with the guidelines dated 27/1/2016 issued by the Government of Orissa, Revenue and Disaster Management Department, and pay compensation to the landowners as expeditiously as possible, preferably within a period of 4 months from the date of communication/production of the copy of this order.
Oh. More than almost 8 months have passed. So you obtain the up-to-date instruction.
Instruction next week.
No, we'll sit another date, but you have to obtain because this is the letter dated 13/12/2024. How kichi paina diya pare? 13/12/2024 এটা সেই ডেট 19/3 পূর্ব এটা ওটা কোন পাইছেন ওয়ান সাইড filing of the compliance affidavit to the additional she lechishanti. File the complaint, the last chance to show that ନାଇଁ ତାପରେ ଆପଣଙ୍କର ଲେଟର ବି ଲେଖିଥିଲେ ଆପଣ 1525 ରେ ତାର କିଛି ଆସିନାହାନ୍ତି। ଆଚ୍ଛା। The Land Council for the state placed before us the letter dated 13/12/2024 of the Collector and District Magistrate Jajpur, wherein it is stated that as per the order of this court dated 18/4/2024 passed in WPC number so and so regarding payment of compensation in the land acquisition case by way of direct purchase. The allotment was sought for from the Director R&R cum Additional Secretary to the Government Water Resources Department, vide letter number so and so so and so, and a reminder has been also issued. Payment has not been made till now, and once the allotment is received, the payment will be made forthwith. The Land Council for the state submitted that on 1/5/2025, another letter was issued from the AG office to the Additional Chief Secretary to the Government Revenue and Disaster Management Department, Bhubaneswar, Collector Jajpur, Land Acquisition Officer Jajpur, Executive Engineer, Irrigation Division Jajpur, for compliance of the order, but no response has been received. She seeks some further time to obtain instruction in the matter, put up this matter, data may file the decision.
Item 4.
On behalf of Viraja Prasad, it is instruction that the matter has been, order has been complied with. The Land Council for the, you give your name, so and so, appearing for Mr. B.P. Das, Viraja Prasad submits that the order has been complied with, and therefore is this content petition be disposed of. Accordingly, the content petition is disposed of. Yes. Obliged.
Item 5.
5 is self-filed.
Here it is. Page 16 of the brief. Page 16, paragraph 12 is the operative part of the judgment of this honorable court.
SLP has
Item
been
5.
ordered. You give us the about the progress of this status of this, because this is simply a diary number has been there, where perhaps some
Next date I will.
defects are there, perhaps that is how.
And that too, it has been, that diary has been registered after the contempt was filed.
Obviously that appears. The Land Council for the state has produced the written instruction received from FACOM Special Secretary to the Government 8/8/2025, wherein it is mentioned that the government has already preferred SLP by diary number so and so before the Honorable Supreme Court, challenging the order dated 24/6/2024 in WPC number 334/2024, passed by this court. Since the Land Council for the documents are taken on record, Land Council for the state 6, you let it be after 4 weeks. I'm a date fix up for the to obtain the status of the SLP. Put up this matter. Yes.
But appearance Mr. Mukherjee along with PC Naik may be recorded. That's up. Appearance of Mr. Mukherjee may be recorded.
No, obviously, no, Mr. Gautam Mukherjee, senior advocate, along with Aukan.
Myself, I have been similar since viral. I could not present.
Prabhu Chandra Naik,
Yes, sir.
S.K.Sahoo Hon'Ble. Yes.
Obliged.
Item 6.
Subhranshu Mahanti not there.
Filing of certified copy.
Ah,
Petitioner to file certified copy of the order.
maybe person is so IN number so for recalling the order dated with a dispose of case. No, the review petition was dismissed because of that filing of the certified copy of the order. So he has perhaps filed an application to recall that order, Acha, 7324. What is that petition? IA number 96 of, okay. Was not available to the petitioner and the custodian. We accepted it. What was it? Accept but the council is not there. Non-appears kar diyon to 8 জন করবেন.
Item 7.
7 let's say the permit of withdrawal also. Permit withdrawal. I am filing memo. So then the meantime, what has been compared and pass in the OA. That I have finished the copy also.
Mr. Mahapatra, Land Council appearing, Senior Panel Council appearing for the Union of India, files a memo for withdrawal of the review petition. Memo is taken on record. Review petition is disposed of as withdrawn.
Item 8.
Here the matter relates to non-payment of the one annual increment. And this could directly consider, but in the contempt there is delay in filing.
How much delay is there?
94 days.
94 days. Notice has been issued.
Government.
Now, who are the parties in the
notice registered civil court Gachpasi. Notice has not been.
Item 5. Address.
Prashanna Kumar Behera, registered civil court. So he might not be there or now.
I will take
Are you?
instruction, I will correct it.
If he's there, it is okay. But otherwise, you have to amend this.
I will take
Take
instruction.
instruction. The Land Council for the IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 94 days in preferring this contempt petition. The Land Council for the petition of Mr. Bahali submits that he may be given some time to ascertain whether the person named as the contemner is the registered civil court Gajpati at Parlak Mundi or not. Put up this matter. Do it for the family culture. Yes.
Item 9.
Item 9, I'm appearing for the contemner. I have filed a compliance affidavit. The order has been compliant in the meantime. I have already filed now.
Right. Acha, listen. The Land Council appearing for the opposite party number 1 and 2 filed the compliance affidavit. Peer the same.
3 and 4 also filed.
The 3 and 4 भी फाइल कर देंगे
क्वेश्चन शो कर
तो कोई जरूरत नहीं हो compliance तो ये जो is anybody is appearing for the petition? The Land Council for the petition is present in view of the compliance of the order. The contempt petition is disposed of.